Hey, everybody. Happy Friday. Welcome to Children of Darkness and Light. I'm your host, the good Lori Hellis. And tonight is a time to talk all things Lori Vallow, the bad Lori, and Chad Daybell. So welcome, everybody. And I'm so glad that y'all joined us. I'm just going to give us a couple of minutes to let everybody catch up and hop into chat. Thanks for joining us. I see that there's a few folks that I haven't seen in a while. And so welcome. And I'm glad you're all here. Somebody asked me the other day what I was drinking. So this is my favorite holiday drink. It is called a Bad Santa. And I've got the recipe up here. It'll be in my newsletter that's coming out tomorrow. And anybody who wants it will post it in the show notes as well. So welcome. And we're getting ever closer to Christmas these days. I'll pop that slide back up later in the show and share it with y'all later. So don't think it's gone forever. We have lots to chat about today. A couple things. First of all, we need to talk about Judge Boyce's decisions about the motions that I filed back in September, asking him to unseal some of the sealed documents. So the question is, did I win? The answer is you win some, you lose some, I guess. Overall, I was not super excited about the number of documents that he unsealed, but he actually did unseal a few for a variety of reasons. And also, I grabbed the wrong document. So let me get the right document here so we can talk about it. So all in all, I think I accomplished what I wanted to do, which was to draw to the court's attention the fact that he was not following the law when it came to sealing documents. He went through the entire list of all of the documents, which I have here, and I'm not going to suggest that you should be able to read that. I will make sure to post the link to this document for anybody who actually wants to wade through reading it. He did unseal probably 15 different documents. Interestingly enough, I don't know that there was any of it that was particularly substantive or gave us any better information about what's going on in the case. The part that he did not unseal had to do with the motions to disqualify the out-of-state prosecutor, the motions to disqualify Rob Wood, the motions to disqualify Lindsay Blake, all based on what and a motion to dismiss the indictment, all based on information. The information I have is that it was based on the misconduct that happened early in the case, having to do with the posts that were in a community Facebook post, county-wide employee community Facebook posts, having to do with people commenting on the evidence, commenting on the sorry, got distracted by chat, commenting on the evidence and commenting on the defendants prior to their being charged. Those who asked if I went to Rexburg this week for the status conference, I did not. I'm kind of sorry I didn't go, only because Lori and Chad were in the courtroom together for the first time. We've had some sort of conflicting reports from folks, um, and as to what their reaction was. Nate Eaton said they both stared straight ahead and didn't look at each other. Somebody else in the courtroom said that they were exchanging glances. I don't know, but I would be more inclined to believe that Chad's attorneys advised him, don't look at her. And I would be very surprised if Lori's attorneys had not also advised her not to look at him. I think it might have been a little bit harder for her to maintain than him, but nonetheless, they were both in the courtroom. And the big news that came out of that hearing is we have a trial date. I am going to go back and talk a little bit more about the motions, but I do want to talk about the trial date because I've had quite a few questions about the speedy trial aspect. And so I wanted to go back through and talk through that. Lori's speedy trial period began to run after she was declared competent and arraigned on the charges. If you remember, her competency, the issues surrounding her competency came up prior to her being indicted for the murders. And they knew the indictments had been filed, but prior to her being arraigned on those indictments, her case was stayed and she was declared incompetent. And then she spent that 10 months in treatment. And it wasn't until she came out of that treatment that she was arraigned on that indictment. That's what starts the speedy trial clock running, is that arraignment. So she was arraigned, speedy trial clock began to run. According to my calculations, it ran in October, although there was some time in September and October where the judge stayed her case because they wanted another evaluation. So the time that case was stayed does not count towards speedy trial. It is what is called tolled. So that time was tolled. According to Jim Archibald, they needed to have a trial date set in February in order to be within her speedy trial window. The judge decided, and once again, because of, T. Diva, that's a really good question, and I'll get to that. The judge has decided before this that he could push the speedy trial deadline with good cause, and found earlier that there was good cause to extend that. He's still finding that there is good cause to extend that in order to keep the trial together and to accommodate Ada County. Remember that the judge had to go back to Ada County and discuss and negotiate with them dates that were going to work for Ada County to have the trial here in Boise. So COVID in this case, did not affect speedy trial issues. Now, I think there were cases where COVID did impact that, and they were holding jury trials and doing the best they could to hold jury trials during the COVID lockdown. But I don't believe COVID had a particular impact on this case. The impact that it had on this case was there was a full year from the time the children's bodies were found until, excuse me, until um, the case went to the grand jury. The reason why it took that long was because the court was not convening grand juries because of COVID protocols. So it wasn't until those COVID protocols were lifted that, in fact, they were able to convene a grand jury. The grand jury was convened, the indictments came down from the grand jury, and before Lori could be arraigned, she was found incompetent. So that 10 months that she was in treatment didn't count toward her speedy trial rights because her speedy trial, the clock didn't start to run until she was arraigned on the indictment. And that didn't happen until after she got out of her treatment. So her speedy trial rights began to run once that arraignment happened. And according to Jim Archibald, he believes her speedy trial rights meant that there had to be a trial set in February. So the case law is not very specific about what period of time is considered too long, but it doesn't appear that somewhere around 90 days would be considered too long if there's good cause. And I think the judge found that there was good cause for two reasons. One, because that was the date that Ada County could accommodate the trial because of the change of venue. And then two, because this judge has insisted that these cases are going to be tried together. And the joint trial piece of it, he had already granted a continuance to give John Pryor some additional time to prepare. I'm here to tell you that the difference between January and April is really de minimis, as they say. It is really nominal. It is not going to make a difference in the preparation for the trial. I know John Pryor was asking that the court set it into 2024. And the judge, of course, wasn't willing to do that because of the speedy trial issue impacting Lori. So, at this point, I don't know that there is a colorable appeal on speedy trial rights. Jim Archibald has said that he is going to appeal the issue and ask for Lori's case to be dismissed. But based on the case law, I don't know that he gets there with a February to April delay. I think that considering that the case has to be tried in Ada County, and Ada County has to accommodate a 10-week trial, I think really probably it stands up to an appeal. It stands up to an appellate challenge. So, when it comes to the documents, specifically, here's an interesting. This is Idaho. In every other state that I've practiced in Arizona and in Oregon, both, the state database includes a link that you can get on the state as a public member of the public. You can get on the state database, court database, and there is a clickable link for every scanned document. So anybody can pull up any court document that's not sealed by the court. Idaho's not that way. The public cannot call up from their own computer any filed document in the database. For me to access those documents, I have to go to a courthouse terminal and read them on a courthouse terminal. And if I want copies, I have to request those copies from Fremont County. I can't just, even though I can click on a link and see the whole document because it's been scanned into their system, I can't just push a button and say, I want a copy of this document, um, because that's not the way the Ada County system works. So when I asked them to copy some documents for me, they said, "Oh, no, no, you have to go to Fremont County." So it's a very restrictive system. Um, if I want to actually physically see a document, I have to go to the terminal in Ada County, and I can't actually get a physical copy of it unless I request it from Fremont County. The other alternative is to ask the Idaho Supreme Court to allow me to access the database the same way that lawyers or other people do. Now, it doesn't mean that I will have access to sealed documents because that is not permissible, and I would not want to do that. But it does. I have requested that they find that I have a journalistic purpose for using those documents, and that I can access them from my own computer the same as I would do from the courthouse. So we'll see whether they approve that or not. It's a very cumbersome kind of backward system, and I don't know the purpose, but it seems to me that the purpose is to really limit the public access. The other thing is that if you want a copy of a document, I have to go to Fremont County and pay $1 a page. That's going to add up pretty quick. So I'm waiting to see what their decision is. But the documents that I was most interested in were, of course, the document that the judge absolutely refused to open and unseal. So, hi T Diva. Yeah, the system itself, the Odyssey, it's called, database system, which is the one that most state courts use, has been around 10 years. It's updated routinely. And like I say, other jurisdictions, I can just call up the database and click on a link, and I can download that document, print it, do whatever I want with it, because it's a public document. But I don't know why, other than the fact that at $1 a page, maybe it's a revenue. Maybe it raises revenue. I don't know. But I have requested that they give me access, and we'll see whether the Supreme Court agrees that that I should have access. So they tell me that I should expect an answer within 10 days. I think it was 3 business days. So we'll see. Maybe next week I'll know. But it is it's kind of indicative of the Idaho system. The Idaho system tends to be a little bit backward, a little bit restrictive, um, and and I'm seeing that in a lot of places, not just in the document access. So it's pretty interesting. Um, so what can we expect come April 3rd? If in fact this case goes, which I kind of expect it will, I think that Judge Boyce has granted his last continuance. And the only thing I can think of that could possibly create another delay would be if John Pryor withdrew and asked for um, indigent defense for Chad. I I wondered early on whether his motion to continue possibly was signaling that that was a possibility, but I would have expected him to take some kind of action before now. now that we have a specific trial date, I expect that the trial is going to go forward. Um, so we'll see. The first thing that will happen is that the attorneys will meet with the judge prior to the trial happening, and they will be talking about pretrial issues. Pretrial issues are things like motions in limine. Motions in limine, it's another one of those Latin things that we use. It means a limiting instruction. And so what happens is one side or the other asks the court to rule in advance on evidentiary issues, on whether or not the 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 particular evidence in question is going to be admitted. And what it means is that it means that they don't run the risk of that evidence coming in inadvertently or over somebody's objections. So it's just pretrial motions to limit evidence, to determine, to narrow what's going to be admitted. They also will talk about scheduling issues, witness scheduling, whether or not there are any witnesses coming from out of town who are going to testify, whether or not there are witnesses that might be required to be taken out of order because of that. So they'll look very long and hard at how the trial schedule will work. Once those things are done, then they will bring in a jury panel. They will bring in a group of potential jurors who have been summoned. They often use driver's license records or voter registration records in order to put those lists together. All of that entire pool of potential jurors will be given the jury questionnaire that the prosecution and defense have agreed to. That jury questionnaire will be completed by every potential juror. I'm certain that among those questions will be questions about the death penalty, questions about whether or not they have had prior experience with any of the people involved in the case, questions about church membership, whether or not they are members of the LDS faith or of any other of the 70 religious sects that believe in Joseph Smith and the Book of Mormon. And from there, I'm sure that they will have lots of questions about how a person feels about certain issues. And jury questionnaires are determined ahead of time by negotiation. So the defense and the prosecution negotiate for what they want in the juror questionnaire, and the judge has the final determination about what is asked. Now, the jury questionnaire is just the beginning, because once potential jurors, then all the numbers, every juror is given a number. All those numbers are put into a hat or a bag or a box, and they are pulled out at random. And once those jurors are called, they come and sit in the jury box, and then the next thing that happens is what we call voir dire. Some people pronounce it voir dire. I learned it as voir dire. That is the questioning process that jurors go through to be qualified to sit on this particular jury. So the lawyers will have their jury questionnaires in front of them, and they will also be able then to ask specific questions of specific jurors to get to whether or not that particular juror has any kind of prejudice that would keep them from listening to the evidence, applying the law, and making a decision based on the evidence and the law. So there'll be 2 weeks have been set aside for jury selection. So it's going to be a lengthy process of questioning. And this is also the first opportunity that the jury has to get to know the lawyers and for the lawyers to establish something of a rapport with the jury. It's really the lawyer's only opportunity to have conversations with the jury members, um, and to sort of become a human being and not just that stuffy lawyer. So there's a lot riding on jury selection. And once the trial starts, then the first thing that happens is the prosecution presents their case. The prosecution will present opening statements. The defense will present their version of opening statements. Opening statements are a roadmap to what the evidence is going to show. So it kind of lays out for the jury, here's where we think that here's what we think the timeline is, here's what we think the evidence will show, and here's the order that we're going to present it to you. So the prosecution and the defense both get a shot at that. Because the prosecution has the burden of proof, they get a rebuttal. So they get a second bite at the apple. The next thing that happens is that the prosecution begins to call their witnesses and to present their case in chief. That means they're calling witnesses, asking questions on direct, and the defense is able to cross-examine them. Once the prosecution has completed their case in chief and all of their witnesses are finished, the prosecution will tell the judge, prosecution rests. At that point, the defense will very likely make a motion for what's called a directed verdict. What that means is, Judge, we don't think the prosecution met their burden of proof, so we want you to find for us before we ever put any evidence on. It is a very rare occurrence to have a judge say, you're right, I'm going to find for the defense. The reason for that is that the evidence that's presented has to be taken in the light most favorable to the prosecution. So giving the prosecution the benefit of the doubt. The reason for that is because we believe that the jury should be the finder of fact and not the judge in a jury trial. Now, there are cases where the judge is the finder of fact because the defendant has waived jury and asked that a judge make a decision about the facts and the law, and has asked for what we call a bench trial. But in typical jury hearings, jury trials, it's rare for a judge to say, you're right, the prosecution didn't prove their case. So the next step then is the defense will present their case. They're going to present their witnesses that they're going to ask on direct examination, and then the prosecution will have the opportunity to cross-examine the defense witnesses. After both of those, after all the witnesses have been heard and the defense rests, then the next thing that happens is that the judge will sit down and make sure that all of the trial exhibits have been properly admitted and that there are no questions and no disputes about that evidence. The reason for that is because those exhibits are going to go to the jury while the jury deliberates. So the court wants to make sure that they've all been properly admitted and that they've all been appropriately marked and that they are what they say they are. And so it is just an administrative chore. You saw that in the Wagner case. A lot of people were very confused about the fact that the judge and the attorneys were going over the information, over the trial exhibits, and were very methodically trying to make sure all those exhibits were where they said they were, what they said they were, that they'd all been admitted, that they were all properly marked, because that makes a big difference when they go and it goes back to the jury. If the jury's relying on a piece of information and later it's discovered that just administrative oversight in the process of the trial, that particular exhibit didn't get admitted to the record, it can't become an issue on appeal because there's nothing to that document's missing. So it is important that that process happen. The next thing that will happen is that the judge will give the jury instructions. Jury instructions are written. They are submitted to the court in advance. There is a whole volume of accepted and standard jury instructions. Now, either side can ask that those standard universal jury instructions, uniform jury instructions, be modified in some way. And if that's the case, then they have to justify why they need to modify the jury instructions, and everyone has to agree, or the judge has to order it over the objection of one or the other. So once the judge has determined that all the jury instructions have been agreed to, or the judge overrules the objections and orders them, then the judge will literally sit and read every one of those jury instructions to the jury. For those sitting outside the jury box, it's tediously boring. For the jury, it's critically important. Now, generally, those written jury instructions will also be sent to the jury with the jury so that they can review them. Varies from state to state. In Oregon, for quite some time, the judge recorded themselves reading the jury instructions, and the recording of that was sent back to the jury. But in most cases these days, those jury instructions go to the jury in written form, along with all the trial exhibits. So the jury then is instructed on the law and how they are, what they're required to find in terms of applying the law to the facts, and they're given a jury form. Jury forms can be really long. I mean, they can be pages and pages, depending on the number of counts and the number of and the number of aggravating factors or additional factors that go into the guilty finding. So, for example, in a case where you have someone who committed a robbery, the jury instruction will, if it's an armed robbery, the jury instruction will, or jury form will include a box to mark that the jury found that the person used a deadly weapon in the crime. So jury instructions and then jury forms, jury verdict forms. And then the jury retires to the jury room. They're instructed that they cannot do any outside research, that they cannot discuss the case with one another until they are deliberating. And the judge instructs them to go into the jury room, select a foreman, and then begin deliberating. There is no set formula for how juries deliberate. They literally sit down and figure out what the process of deliberation is going to look like. So the jury foreman could sit down and say, okay, how do we approach this? We're going to do it chronologically, or we're going to do it based on the way the evidence came in. And in the end, they determine kind of what a process will be, and they begin to deliberate. What that means is they probably initially poll the group and ask whether or not people have made decisions on a particular count of the crime. And if not, then what sort of questions do they have and what sort of evidence do they want to review before they make a determination? Once the jury has, um, so during deliberations, a jury can send questions to the judge. And we all know about hung juries. We know about juries who cannot reach a unanimous decision. And in most states, a unanimous decision is required in order to convict someone. So we've all heard about juries where we have one juror that's a holdout or one juror who just simply can't, who just can't get there. And in that case, the judge would say the jury can't reach a decision, and for that reason, the judge declares a mistrial. And at that point, then the prosecutor has to determine whether or not the defendants would be retried. Um, in general, usually, defendants are retried. On occasion, especially in cases that are very old or where, perhaps the prosecution has had difficulty proving the case, a prosecutor could decide not to retry the case, and that does happen occasionally. So once the jury reaches a decision, they inform the court and reconvenes all of the people in the trial. So reconvenes the attorneys and the court staff, and and then the judge takes the verdict. In general, once the jurors provide their verdict, the judge will thank them for their participation and their service and will release them. And then at that point, the judge will determine when sentencing will occur. Now, in a death penalty case, the next thing that would happen is that the jury would be asked to reconvene to hear the penalty phase. And in the penalty phase, that same jury would be asked to consider whether or not there have been any mitigating circumstances that would justify a finding of life in prison without parole rather than imposition of the death penalty. So, the jury that is going to hear this 10-week trial is also the jury that is going to hear the death penalty portion. I did see a question in chat about two juries. There has been no indication at this point that the judge is considering two juries, a jury for each defendant. I've said before that it is managing a complex jury trial, a death penalty case, is in itself like being a combination of a traffic cop and a juggler. The judge really has to keep everything moving, keep it on track, juggle a lot of moving parts, making decisions, snap decisions on matters of evidence, on objections, and as well, having to try and make sure that evidence that's going to the jury is appropriate to be heard by the jury. And that is even more difficult if you are dealing with two juries, because what comes in for Lori, his Chad's counsel may argue isn't appropriate to be heard by Chad's jury, and vice versa. And trying to keep all that straight while you're directing traffic and trying to make snap decisions and rulings on objections, it's a lot. It's exhausting, and I don't think that, to be completely honest, I don't think Judge Boyce is up to it. I don't think that he has the experience in the courtroom that would allow him to keep juggling. So I know we have a lot of questions. I've I've gone about 40 minutes now, and so I like to leave the rest of the show for questions. We could go a little long tonight. I know that Hidden True Crime. I saw a notice that their family is under the weather, and so they are not going live tonight. They're going live tomorrow. And I know that Gigi from Pretty Lies and Alibis has an interesting show that some folks may be interested in, but it is the kind of thing that doesn't necessarily have to be done live. Big E from Chasing Paper has gotten paid for copies of the transcripts in the Wagner trial of Jake Wagner and Angela Wagner's testimony. They were the two witnesses who testified against Angela's son, Jake's brother, George. And because in that trial, witnesses could opt out of being live streamed, and they both did. The only way to find out what really was said in those testimonies is to do it with a transcript. So Gigi and Big E are going to be reading those transcripts as if it were going on. Gigi will be the prosecutor, and Big E will be Jake, and they will are reading those. That's on Pretty Lies and Alibis. I know I think it's going on right now, but it is something that you could join in progress or catch up with later. Because the Wagner case has already been decided. George Wagner was found guilty on all charges and is due to be sentenced, I want to say next week, but it could be after the first of the year. I'm not positive. As I said that, I thought, I might not be sure about that. So his sentencing is coming up. And the death penalty is off the table. So it'll be a life without parole sentence for him. So let's start with Kathleen's question. If Pryor withdraws and or Lori decompensates, do you think that Judge Boyce will decide to sever? Well, if John Pryor withdraws and Chad suddenly needs a public defender, and a public defender needs to get up to speed for the case, a public defender is going to get extra time. Lori will not waive her speedy trial. We know that. And so then Judge Boyce is going to have to make a decision whether to sever to allow Chad additional time for new lawyers to get up to speed. So I think in that instance, I think it's possible. Because Chad has already waived his speedy trial right, and it's clear that he is not in a rush to go to trial, I don't know if Lori were to decompensate and be declared incompetent. I think there's a likelihood that the judge would order that Chad's trial go forward and that Lori be tried at whatever time she becomes competent again. So that's a great question. Thank you, Kathleen. Shannon, would John Pryor stay for fame? This case is huge worldwide. I don't know John Pryor well enough to know for sure, but what I do know of him, he does not strike me as the guy who is out there for fame. He strikes me as a hardworking defense attorney who's he doesn't strike me as the kind of lawyer who's been out there trying to scare up high profile cases before. I think this case just kind of fell into his lap. So he doesn't necessarily strike me as the kind of person who would just stay on for the fame. I do understand that when you take on a client, you have there is a really deep sense of responsibility to your client. That is just And I think it is especially true of defense attorneys. I think we're wired to go to bat for the underdog, and I think that it's very difficult for us if we have made given clients assurances, um, to step back and say, I realize I said I was in this for the long haul, but it really is in your best interest for you to think about a public defender. That's a hard conversation to have when you've made those given your client those kind of assurances. I've got your back. I'm in it for the long run. And to have to back away from that, even when it's in your client's best interest, that's hard. It just sticks right here. So I don't I cannot say one way or the other, it that I can't say definitively that John Pryor is not interested in the fact that this is a high profile case and he's in it for fame, but I don't necessarily get that impression. I think that he has other motives. He's a drama queen. Yeah, he is. I just caught that in the chat from Sarah. Yeah, there's no question. He is he's a bit of a showman. He's gonna puff his chest up, and he's going to because that is his defense persona. Um, it just is. Yeah, that doesn't really take away from the fact that I think he's a competent lawyer, and I think that he, definitely has uh, his client's best interest at heart. Dawn, how can they get around the children being on Chad's property? Evil uncle snuck in and put them there. Well, I think so. I mean, what we have heard from Chad's kids is Emma saying, "My dad's not stupid enough to have buried these kids in our yard." It has to have been that they were buried here when and we didn't know it. Um, I think that's a I think that's a hard sell to a jury, no question. But remember that lawyers have to make those hard arguments. You know, when I was practicing, we used to laugh about there were certain arguments that you had to put a bag over your head to go to court and make. And we had a fellow who was in our group, and he was a great guy. We all loved him. He was the guy who was most likely to go to court and to make those arguments that the rest of us would be like, "I need the bag." And he had the best win-loss record of anybody in our group because he was the guy who was willing to go and make those arguments, and every once in a while he won one. So, yeah, I think it's gonna be tough to go back to make that argument that evil uncle snuck onto the property and buried the children there when nobody was looking. But I think that's an argument you're gonna hear because that's that's all they got. So, no, lawyers can't lie. Good question. Um, Lawyers can't lie. And they can't suborn perjury from a witness or their client. If they know that their client is going to get on the stand and lie, they can't put their client on the stand. So I think that you will find that Chad Daybell has been telling his lawyer from the beginning, "I didn't do it. I didn't hurt those kids. I didn't bury them in my backyard." And that is his story, and he's sticking to it. And do I know if the judge will allow audio in the courtroom? Can we at least listen to the trial? I don't know. Um, I have talked to some of the family members, and I know that they're very concerned that it's if the trial is not at least audio streamed, it is going to be a terrible hardship for them. I don't know what the judge will decide. I think there is a 50-50 chance that he is going to allow some sort of access for the public live, whether that's audio in the courtroom or whether it is permitting live stream. I don't know. I think there's enough pressure on the courthouse itself because of the sheer number of people who want to attend the trial. And I think that that there is some pressure being brought to bear by the family members, particularly in the Vallow family and JJ's family and Kay and Larry Woodcock. Um, Unfortunately, a lot of the folks who are um, deeply interested in the outcome of this trial are older and have some health problems. And so the very idea that these folks are going to come to Boise and live in Boise for 10 weeks while this trial goes on is just impossible. It's impossible for the family members that have jobs. It's impossible um, for the Daybell family. I know Heather Daybell said it would be a terrible hardship for her family um, because they have jobs. So I'm hoping that the judge is going to make some provisions and perhaps um, allow either audio from the courtroom or full on live stream. So I, I think it's at least possible that he will back off from the pretrial no cameras in the courtroom. Um, Generally, what would happen is that media would be allowed to get the recordings of the day's proceedings as soon as they were closed. That's what's been happening in Fremont County with the hearings. And then they would be able to review them and broadcast them later. So I I hope that Judge Boyce is going to take another look at that. Tara, hi Tara. Do you think Chad justifies lying about the kids because he is a prophet in his own mind or has convinced himself he didn't have involvement? You know, I can't say what's in Chad Daybell's mind. We would all probably be terrified if we knew what Chad Daybell is thinking and what's in his mind. Um, I don't know that it has anything to do with him being a prophet. I think that he simply is denying that he had any involvement, and that is the story he's sticking to. So it's scary. Hi, Trish the trucker. If lawyers can't lie, I'm from a trucking family, by the way. I have a branch in my family that are have been in the trucking industry for years, and a family member of mine is actually the original inventor of the fifth wheel trailer hitch. So for Trisha the trucker, that's a gee whiz. If lawyers can't lie, then do clients lie to their lawyers every day, all the time? And doesn't that hurt the defense lawyers when they don't know the truth? Yes and no. Um, the place where this becomes most difficult is if your client is going to testify. Because if your client tells you, like in the Wagner case, George Wagner got on the stand and everybody was pretty shocked to see George on the stand. Had George told his lawyer, I really was there that night. I didn't shoot anybody, but I really was there. And that's the reason my footprints are there. And that I wore the shoes and I was there. Then the lawyer couldn't put George on the stand and have George say, I was never there. Um, because the lawyer knows that's not true. In the instance where the client, such as Chad, has stuck to his story, I wasn't there, I didn't hurt the kids, I didn't bury him in the backyard, then I think that John Pryor is free to present that case to the court. It is not the lawyer's job to be the lie detector. Um, it is the job of the jury to determine what evidence is credible and what is not. And the lawyer is not the gatekeeper for that. I know that sounds a little weird. Um, I would never, and I'm sure John Pryor would not either, ever suggest that um, if I knew something to the opposite, that I would ever let my client go on the stand and perjure themselves. But in the case where my client says, this is the way it happened, and that is my story, and I'm sticking to it, to quote Jimmy Buffett, um, then it is the lawyer's responsibility to go and present their client's case to the jury, and for the jury to weigh their client's credibility, the same way they weighed the credibility of George Wagner. And clearly the jury didn't believe what George was saying because they found him guilty on all those charges. So um, this is an issue which really goes to the heart of personal ethics. So there are a lot of lawyers, defense lawyers, who will sit down with a client and say, I don't want you to tell me whether you did it or not. Because if you do, it hamstrings me. Um, there are also a lot of lawyers who will sit down and say to a client, tell me what happened, but understand that if you later decide that you want to testify, I can't have you go on the stand and tell a different story than what you tell me today. If you're not comfortable with that, then don't tell me. Because a lawyer's job really is to put on a case based on the evidence, not on what their client says, based on the evidence that the state has. And the lawyer's job is to prove that the state has not proven their case beyond a reasonable doubt. So whether their client tells them anything about what happened or not, the lawyer is going to trial to present evidence to the jury. Um, the evidence is going to show that Chad probably was more involved than he says he was. Does that mean that his lawyer's lying? No, it means that his lawyer is dealing with the evidence that the state is presenting at trial and trying to poke holes in the state's story, trying to draw to the attention of the jury those places where the evidence doesn't necessarily support what the prosecutor's saying it does. So I know, I know a lot of people have a little bit of trouble with this concept. And it is a concept that lawyers grapple with their entire careers, all 27 years. It is a tightrope that lawyers walk. And every lawyer has to do a little bit of their own internal work and their own self reflection and decide how they approach the issue with their clients. Crocheting Bammy. I don't know. Does that mean you're from Alabama? Or is Bammy like Grammy? Either way. Question. If we as Joe Public can see that everything coming out of the witness's mouth is a lie, how can Rob Wood put any stock in them testifying with the truth? Are you satisfied he can convict? You know, here's the problem. I have not seen all the evidence. This is an interesting tidbit that came out of this week's trial. The prosecution just gave John Pryor 150 pieces of new evidence. Let that sink in for a minute. If you don't think the prosecution is trying to sandbag the defense, you do not hand 150 discrete pieces of evidence on a memory stick to the defense 3 months before the trial. Um, if I were in Jim Archibald's shoes, I would be screaming, and John Pryor's shoes, I would be screaming bloody murder, because that's clearly, they better have a damn good reason why they couldn't get that discovery to John Pryor sooner. That's outrageous to me. So I can't tell you whether I am satisfied that Rob Wood can convict or not. Yeah, Michelle, that's right. He said significant. 150 pieces. That's significant. I was stunned when I heard that. And John Pryor was rightfully outraged at that. I remember having a case, and it was a case that is nowhere near this serious. It was a burglary and robbery case, and I got to trial readiness, which is usually 2 days before trial. So trial readiness was on Thursday at 4 o'clock, and my trial started Monday morning. And the district attorney walked in and set 8, at this point, they were VCR tapes, right? Back in the VHS tapes, on the table in front of me, and said, "We just realized we didn't give you this." I'm here to tell you, I about lost my mind. And I just looked at the judge and I said, "There are more hours of interviews on these VHS tapes than there are hours between now and the time trial starts. And I want a dismissal now, and I want it with prejudice," meaning they couldn't bring the charges again. And it was one of the only times in my career that the judge said, "Ms. Hellis, you're right. This was absolutely egregious. There was no excuse for them not." Oh, they just found that they hadn't given me these hours and hours of VHS tapes. So, I mean, I don't know, because I haven't seen the box. We haven't seen any of the evidence the prosecution has. So how can I judge whether that evidence is going to be adequate to convict? Um, and if they're just now turning up evidence in that much, in that volume, I don't think they know either. So that's my 2 cents. If we as Joe Public can see everything coming out of Melanie Gibbs, Zulema, etc.'s mouth as a lie, how can Rob Wood put any stock in them testifying with the truth? Are you satisfied he can convict? Okay, so let's talk about Melanie and Zulema and Melanice. We know that Zulema has a limited immunity agreement, and that if she does not testify as her pursuant to her proffer, that agreement could be nullified, and she could be prosecuted for whatever crime it is that the prosecution believes they have against her in Arizona. Likewise, I think that there are immunity agreements for Melanie Gibb and Melanice. And here's the reason I say that. For Melanie Gibb, if you remember way back when Mark Means was still on the case, and he wanted information from Melanie Gibb, and he tried every which way he could to get information from Melanie Gibb. He wanted her text messages, her emails, her phone records, and he served her with a summons that asked her, directed her with no legal authority to produce all those things. the very first thing that Melanie Gibbs said when the prosecutor or when the process server handed her those documents was, "Call Rob Wood." That to me was the red flag that Rob Wood has an immunity agreement with her. Because otherwise, why in the world would she be saying, "Call Rob Wood"? The average person would be saying, "Call my lawyer." But her response was, "Call Rob Wood." I think that telegraphed that she has an immunity agreement. The other person is Melanie's. Now, this is for those of you who might be not familiar with the case. There are two Melanies in this case. Melanie Gibb was one of Lori's close friends and deeply involved in the whole cult aspect of this. Melanie Boudreaux, now Pulowski, is Lori's niece, daughter of her deceased sister, elder sister Stacy. And Melanie Pulowski, we all call her Melanice just to keep her straight. About 6 months ago, was charged with some identity theft charges out of Arizona, having to do with her accessing her ex-husband, Brandon Boudreaux's bank account after she should not have had access to it in their divorce. And the charges were filed. They sat there and kind of perked for a few days, and then they were dismissed. I think that was a very clear signal that law enforcement has said to her, and the prosecutor has said to her, and remember, the prosecutors in Arizona and Idaho are talking to one another. The prosecutor has said to her, "If you go and testify honestly, we won't pursue those charges." And I think they brought those charges to get leverage over her because she wasn't talking. So I think they found leverage over her. She's now talking. Truthfulness. Everybody lies. If you ask Scott Reich, he will tell you everybody lies. Um, it is the job of the jury to weigh credibility and to decide who is telling the truth. The jury is identified as the finder of fact. And that is, they are the body who decides what is true, what is not, what the most compelling evidence is. All of those decisions are made by the jury who finds the fact. I think that it is possible for Rob Wood to present those witnesses, and I think it will be the responsibility of the defense to impeach them by showing their propensity for mistrustfulness or their propensity for untruthfulness. And it'll be up to the defense to poke holes in their stories. In some ways, that may be easier for some than others. I mean, let's face it, there's a lot of information out there in the Ethernet about Melanie Gibb, including a phone call she had with Sherry Dowdle that clearly indicates that she knew what happens to people who become zombies. And she said, the kids are zombies. So I think Melanie Gibb is a lot harder witness to rehabilitate than the others, but I think I think there are agreements. Now Colby's a different situation. And I honestly don't know how much they will be using Colby in this trial. Because Colby didn't have much contact with anyone after Lori moved to Rexburg. In fact, at least initially, he didn't know where they were. He was told she was moving somewhere cold, but he didn't know where. She could have been in Alaska. He didn't know where she was. So I don't know that he had that much contact during that period of time where he could have had information that would be helpful to the prosecution. Certainly, he is a more important witness when it comes to Charles' murder in Arizona. He clearly knew the family, understood the dynamic, was of an age when he would be able to report that. He wasn't a young child; he was an adult, and so his observations are maybe a little more um, believable. And so I think Colby will be much more instrumental in the charges having to do with Charles's death. I'm not so sure that they you I may be surprised, but, I wouldn't be surprised if they don't call Colby at all in the Rexburg cases. Sandy, Chad's probable cause hearing showed the state had lots of solid evidence. So do you know why Wood is seeming to not play straight? That's a really good question. Um, and we're at about an hour and 15 minutes. I'm gonna go ahead and go for a few more minutes, and then we'll wrap up. Um, I I have some interesting things to talk about on Wednesday, on True Crime Wednesday, where we talk about cases other than Vallow Daybell. You all have been sending me great leads and great cases to look at, and we had a great time talking about insanity defenses and the way that those play out in some other cases. I know I want to talk on Wednesday about Ethan Crumley, who was a school shooter, and his parents have been prosecuted for contributing to his behavior. And that one is a case that really interests me. So, but to get back to Sandy's question, Chad's probable cause hearing showed the state has lots of evidence. So, do you know why Wood is seeming not to play it straight? It is a big case. It is a career building or a career ending case. And that is a lot of pressure. And with pressure comes this Rob Wood has never tried a death penalty case before. So he's inexperienced. Once again, one of those people over his head. And I think that he's found himself on the national stage, international stage, frankly. And it is a combination of not wanting to mess it up and a bit of hubris, frankly. And I have questioned why Rob Wood isn't playing this absolutely straight. Um, but I think that is something that will come out post trial. It is a question that I am acutely interested in. And believe me, this question of the appropriateness of the prosecution, of the judges, of all of those things, I'm going to be digging deeply into those issues once the trial is over. Once the trial is over, the court can no longer just indefinitely block access to motions and to all of those things. So that information is going to come to the forefront. Somebody just asked in chat if I had a White Russian or eggnog. This, for my dears who might not have been here when we started out, I'm going to put this slide up so you can all see. This is what I fondly call a bad Santa. It is the recipe's up there. It is Captain Morgan spiced rum, Fireball whiskey, and rum chata, rum cream liqueur, and garnish it with a cinnamon stick and a little nutmeg. And it is my favorite Christmas drink. So enjoy this weekend. We're going to post that recipe in the show notes. So you'll be sure to have it for the weekend. And I'm going to leave this up here for a little while in case anybody wants to jot it down. If Chad sent that pet cemetery text to his wife the day Tylee was murdered, doesn't that place him on his own property that day, there with Alex? Well, I don't it's a great question, Sarah. I don't know because we don't know about Chad's cell phone location data. We know that the cell phone location data that was used was Alex's. So we know that Alex's phone cell phone location data pinpointed where he was, that he was in Chad's backyard. We know that at some point Chad sent this text to Tammy about burning limbs in the backyard. It was kind of Freudian, I think, and the raccoon. We know that that happened, but what we don't know is Chad's cell phone location data. That's something the prosecution has not revealed. It didn't come out at the preliminary hearing. It didn't come out in any of the probable cause statements. So I suspect that they have plenty of cell phone location data and that we're going to get all that at trial. And I suspect that they can locate him on the property as well. So good question. So I think we'll take 2 or 3 more questions and then we'll wrap up for the evening so y'all can go over and check out what Gigi's up to. Do I have any theories on what each of the defense strategies might be? Sure. I think for Chad, the only defense strategy is I was duped by this beautiful blonde goddess and I'm dumb and I didn't know any better and I was swept off my feet and I got wrapped up in this. Yes, I claim to be a prophet. Yes, I got sucked into all of this. Yes, I I believed in multiple probations and I got sucked into all those things. Yes, I believed all the doomsday stuff, but I didn't kill anybody. And and so I just was sucked into all of this because I led with my underwear. Um, I think Lori's strategy is going to be just the opposite. Her team is going to portray her as this wounded, mentally fragile person who was overwhelmed by this person who claimed to be a prophet, who claimed to have all of this mystical power, who claimed to be able to talk to God, who claimed that he knew about all their past lives and he made promises that of all these things that they were going to accomplish together and that they were ultimately going to be in the celestial kingdom together. And I think that is their strategy, is that he was this Svengali who convinced everybody of this strange belief system, and that included Lori, and that Lori was led to do things she would have never done because she was brainwashed and she was extremely fragile and potentially delusional at the time. Now, we've talked about the fact that Idaho doesn't have the death penalty, but what Idaho does have is if you can prove that your client is so mentally ill that they could not form the necessary mental state, they could not form the requisite intent to commit the crime, you can still get that mental health evidence in. So to say she was so brainwashed by Chad and all of this mysticism, this false mysticism that he was peddling, that she could not understand. She believed that whatever they did was justified, that she could not understand that what she was doing was wrong. I don't know that either one of those defenses fly, but I think that's about all they have. I could be wrong because like I say, I haven't seen the box, the evidence. Um, Rhonda, I watched the Casey Anthony docuseries, and it seems she might have been convicted had death penalty not been on the table. Do you think it would be a better outcome if this were not a death penalty case? Absolutely. I think this case would have been over a long time ago if the state had not sought the death penalty. I think we would have seen a trial in October and it would be done. But the death penalty makes everything more complicated, more cumbersome, more everything gets worse when the death penalty is on the table. I have not watched the Casey Anthony docuseries yet. I have read both books, the book that was written by the prosecutor and the book that was written by her defense attorney. Um, but I haven't seen this series. So um, I definitely think that and I'm hoping that I will get some time after the holidays to watch it because I would like to talk about it on True Crime Wednesday. But I really feel like before I did that, I want to go back and reread some portions of those books I've read and and be able to watch the series as well. And it's Christmas, so my family are going to be joining my daughter and her family, her fiance's family for Christmas. Looking forward to it a lot. We had a gathering planned in September and had to cancel it because everybody got COVID. So we're hoping everybody's going to wrap themselves in bubble wrap and hand sanitizer for the next few weeks, and we're hoping we're all going to be healthy and get together down in LA. I know people tell me don't tell people you're not going to be home. But I do have a house sitter, dog sitter, who's going to be here taking care of all our creatures. Um, so yeah, I'm getting ready for all of that. For those of you who have been, I'm turning around here so you can see a little bit of my workspace for quilting. Um, Last year, before I moved, my daughter asked me to make her a lap quilt. We picked out fabrics and it didn't get finished before I moved, and it was in a plastic tub. So that's what she's getting for Christmas. So that's part of my work for Christmas, and to get squares ready for our True Crime Quilt Guild, which is going to start in mid-January. So my plan is, I hope this weekend to get the first video out, and it's just for beginners. If you are not a beginner, it probably won't be at all helpful. But for those who are beginners, I'm just going to go over what tools you need, how to cut fabric, how to match colors, just sort of basic stuff. And then once y'all have had a chance to get that, then I'm going to put out an instructional video for each square, showing you how to put it together. I also had a nice email from the lady whose pattern we're using, for those of you who have downloaded it off Etsy. And she also gave me access to some of her own instructional videos on how to put the pattern together. And I will make sure that we post those so that those who are involved in the Quilt Square month can watch those as well. I think that might be all of the information and administrative stuff that we have time to talk about tonight. Please, please, if you have not had the opportunity yet, please subscribe. Please hit the like button. We have 412 people in chat. I know that there are not that many people who have hit that like button yet, and it really does help with the algorithms. I want to remind everybody, you've seen the little banner at the bottom. We take super chat donations, and we do have a PayPal link for anybody who'd prefer to use that. And all of those donations that you generously send um, eh, go directly to our moderators. And they do a great job. Michelle, Brenda, thank you so much. And we just want them to feel our appreciation for it. Brown Eye Girl just put up, for those of you who might not have seen them, or oh gosh, I always do this backwards. The wristbands look like this. They say justice for Tylee and JJ, or JJ and Tylee. And they are your regular, like, rubber wristbands. And if you send me a self-addressed stamped envelope, so you're paying for the postage, I will send you one for free. Um, my hope is that come April, we are going to flood social media with pictures of us all wearing these. I will have pockets full of them that I will be handing out at trial, outside the courtroom, and anybody who wants one. And so it's just a small thing that we can do to show our support and our solidarity with the families of the victims and with the victims themselves. So we always make sure that that information is in our show notes. On Saturday morning is my morning to sit down with my coffee and go through go through the chat as well as the comments below. I try and respond to as many of them as I can. Please send me ideas for what you want me to talk about and cover on True Crime Wednesdays. And we will be delving into some interesting cases. I know we're going to talk about the Idaho stabbing murders, the University of Idaho students that were murdered. We're going to talk about that. We're going to talk about Ethan Crumley. We're going to talk about whatever else y'all want to hear me weigh in on. So thanks so much for joining us. Thanks. I know that there are a lot of places you could spend your Friday evening. So I appreciate that 400 of you are here tonight with me. I hope that if you get a chance, you'll pop over and check out Gigi and what she and Biggie are doing on reading those Wagner transcripts. And please get in touch if you all have any questions or there's anything else I can do. So until Wednesday, I will tell you, have a great weekend. Make yourself a bad Santa. Wrap those Christmas presents and get in the spirit a little bit. And I will see you Wednesday for more fun and frivolity. Good night.